Hi, good morning, everyone. I'm just going to let everyone come in first before we get started officially, which should be in a couple, like maybe 30 seconds. And then we'll get started. Okay, because I'm still seeing people trickle in yet. 49. Yeah, and I think I'm going to wait maybe 1 minute more, and then once the number stabilizes, we'll get started, okay? Good morning, everyone. Yeah, we'll get started soon. Okay, I think the numbers are slowly stabilizing and maybe at 60. So I think, Yana, do you think we're ready to go?
Yep, go ahead.
Okay.
Yes.
Good morning, everyone. Welcome to this Friday morning session of Working with Precarious Migrants and Refugee Claimants. My name is Edgar Valderrama Medina. I am the Immigration and Refugee Protection Coordinator at the FCJ Refugee Centre. And along with me today is Diana Gallego, the Interim Director of the FCJ. Diana, I'm going to let you talk for a little bit and then we'll get started, okay?
Welcome, everyone. I have a sore throat today, then probably Edgar is going to do most of the talking, but I'm here to support him with any questions or anything that you need today with us. Thank you, Edgar.
No problem. Thank you for being here, Diana, and welcome everyone. Okay, so on to the next slide. I'm just going to do a quick introduction about our organization. We've been working with uprooted people for almost 30 years. We're a nonprofit organization who serve refugees and others at risk due to their immigration status. So it's not only refugee claimants, it's also people who have been in this country without status for a significant amount of time, and who are looking to be who are looking for avenues to regularize their status and establish themselves here and have all the supports they need. We take great pride in offering a very unique wraparound support to our clients. I'm going to go more into detail on how that works into the next slide. So as you can see, today we'll be talking about the immigration and refugee process, but our agency itself offers multiple wraparound supports to help clients deal with intersecting issues about their cases. Rarely you'll see someone who is just dealing with a refugee claim. Because of their circumstances, they'll be facing issues with housing, issues with access to education, issues with work, issues with accessing food, accessing health. And we take great pride in offering this unique wraparound support along with the anti-human trafficking team, which helps both people who survived sex trafficking and not more importantly, and also as well labor exploitation. And as we can see today, we're also committed to increasing everyone's service capacity because it's also very important for other service providers to be able to support refugee claimants and non-status people. So this is why we're more than happy to be here today at this 9 a.m. Webinar. Okay, so today's agenda, we're going to be splitting the presentation in two parts today. We'll first begin with like the entire refugee claim process, and then we'll go on to the humanitarian and compassionate ground application. Depending on our own personal experiences here at the office, our orientations vary between refugee claims and H&C or humanitarian and compassionate grounds applications. And hopefully today you'll have enough information to sort of guide clients to see what venue is more viable for their unique case. Okay, so with the refugee claims, we're going to begin on how to start a refugee claim, the difference between a port of entry and inland claim, the new system that's in play about initiating on refugee claims online, and the previous system that was implemented during the pandemic, because you may be supporting clients who initiated the refugee claim before the new system started, so they still have to deal with the Epost Canada system. After that, we'll take a quick break and we'll allow questions. And then we'll be going into the details about the humanitarian and compassionate grounds applications and how this differs from the refugee claim process, what it means for clients to prepare for. You can also explain that you can apply for Legal Aid Ontario and the eligibility terms for legal aid and how to prepare for that call, because unlike a refugee claim, H&C calls for legal aid are a bit more, require a bit more preparation at hand as well. And the difference between refugee claims and H&C claims to Legal Aid Ontario. So, sorry, one second. So technically since 2004, Canada has entered an agreement with the US where it's been designated as a safe country for refugees to enter and make their own refugee claims. Under this official declaration, both the US and Canada recognize each other as safe countries to accept and process refugee claims and for them to establish themselves here. The reality is another story, because even with the current administration, and especially with the previous one, it's very hard, and there are a lot of systemic issues with that refugee claimants face in the US, and it makes it increasingly appealing and very understandably appealing of why they would want to make a refugee claim here in Canada. And depending on each family's unique immigration circumstances and how they flee, you may find clients whose families are going through different processes because someone was stranded in the US for a significant amount of time, and other family members made it here directly and were able to start their own refugee claims. So it's understanding how to navigate that system as well. So there are exceptions. For example, if you make a refugee claim in the US or have been there a significant amount of time, that allows you to make a refugee claim here in Canada. So it's close family members, which Diana, if I'm correct, it's siblings, parents, cousins, and children, and sons and daughters are a parental relationship, correct?
Yes, it's just the immediate family, the close family members. Yes, parents, children. Yes, aunt, uncle.
And it's important to show that, especially with these exceptions, to have the necessary documentation. So you just can't show up claiming that you're someone's sibling. There has to be a documentation in the form of birth certificates, or for example, if a family member made a claim here in Canada, the basis of claim form that lists this person who's in the US as a spouse, sibling, parent, or child. Other exceptions are the unaccompanied minors and Diana, and the document holder exception, which I haven't had much experience before. Would you mind just going further into that?
Yes, it's those that they don't require it to have a visa to enter to Canada, or that they are holding the ETA.
Okay, and the death penalty as well, because I haven't had that much experience.
If the person who is going to enter to Canada to claim protection, but they don't meet one of these exceptions, but that they can prove if they are sent back to the United States, and then United States will deport them back to their country of origin, they will face the death penalty, because Canada is signatory to the Convention against the death penalty. Also, recently, the Canadian Council for Refugees and a group of lawyers challenged the Canada-US Safety Country Agreement. However, the challenge was lost. In the first decision, the federal court said that United States was not safe, but the government appealed, and the appellants lost in the decision. Then now the safety country agreement is still in place. Means if you don't meet these exemptions, people will be stopped at the border, sent back to United States, and they will get something that is called the exclusion order. Means if they try again to enter like irregularly, like walking from another no official border, they will be not able to claim protection in Canada, because they have this exclusion order that they already kind of claim protection in Canada. Then it has recently we hear that a lot of families that didn't meet the exemptions but were like kind of stuck in the United States, tried to cross the official land borders with Canada, and they were excluded. Then this brings a lot of consequences to families that want to come to Canada.
Thank you. Moving forward, most client interactions through the borders will be with the CBSA, with Canada Borders Agency. And when it comes to especially finding out on how immigration and borders affect us in our sector and our clients, is understanding that CBSA is normally the sort of first contact clients have with immigration. And depending on how savvy a client might be before about the immigration process, they may start the refugee claim there and then in front of CBSA, or they may do a port of entry claim later. And it's also understanding that we've already announced that on October 12th, that in November, we're allowing fully vaccinated travelers to enter Canada from the US, from land and ferry points for non-essential travel. At least in our organization, we've been seeing over the last couple of weeks a significant shift from humanitarian and compassionate orientations to refugee claims. As we can even attest that we already had, at least this last week, a couple calls to Legal Aid Canada for refugee claims and seeking support with those claims instead of H&Cs. But that doesn't mean that the irregular status people have just disappeared. There's still a need there, but now we're going to have to adapt with processing refugee claims and making sure clients get all the necessary supports so their cases are properly presented before the IRB.
Edgar, also Nora in the chat is asking to clarify for the document holder exemption. Like if you are in the United States, if you landed in the United States, but you have a student visa, a work permit to come to Canada, or you are from a country that you don't need a visa to come to Canada, then you are holder of the ETA, then you are able to come. But we know that's why the exception was put there. But we know that anyone that doesn't need a visa to come to Canada, they will not go to the United States. They will arrive directly to Canada. The other exemption is if you hold a student visa or work permit, well, you will arrive into Canada. It's just like a bureaucratic thing to put it there. Okay.
Okay, so we're going to talk about inline claims. So as you stated before, there are two ways to start a refugee claim. First is a port of entry, as the name implies, either through the airport or a land crossing with CBSA. where you're interviewed. You're basically given these, the basis of claim form, your Schedule A, your Schedule 12, your generic form, and you're interviewed, and you begin the process formally by paper, and you even get an acknowledgement of claim, and you're giving a deadline to perfect your forms and your narrative and your basis of claim and submit them to the IRB within 30 days. If I recall, it's still the date for that. The other option is, for example, to make an inline claim. An inline claim can be started via an email to the client, the Canadian Refugee Protection Portal, which is a new system that was implemented in October 6th. We'll be going, it's now the primary means of submitting a claim. And it's basically, you would have to do, I just want to clarify a couple of things about a port of entry claim. We normally recommend always making sure that you have access to a legal representative, preferably an immigration lawyer as opposed to an immigration consultant. And understanding that some, depending on the circumstances on a client, it might be better to wait for other family members to arrive, or it might be better to do a port of entry claim. Also, understanding, for example, that port of entry claim doesn't mean you can stay in Canada a significant amount of time for a couple of years before making a port of entry claim, because at least if, say, 2 years pass before someone makes a refugee claim, it could potentially weaken their refugee claim case, because the sense of urgency about fleeing your country of origin is sort of lost. And you can argue that systemic issues like language, knowledge of the immigration process or the refugee claim process may have barred you from making a refugee claim before, but after a significant amount of time elapses since arrival into Canada and making a port of entry claim, that also affects us as well. But back to the CRPP. So this new process is that you register through the portal, either yourself or your legal representative, to begin the refugee claim. For example, if you made a port of entry claim and you're already given your letter of acknowledgement of claim that gives you a UCI and recognizes your claim process, you can also link that refugee claim process online to it. So any further documentation or any communication can be used or be sent through that portal as opposed to the traditional paper form. While this is if, for example, you're using a representative, you're going to have to, it's not that someone can just create the portal for you and submit for you. They have to have the necessary documentation that where you authorize them to be your representative. It can also be used by clients as well, as we said before, to link their previous port of entry claim to the current process online. And for example, the idea is that all the communications to the IRB, like a medical exam request, your future eligibility interview, and for example, I think your hearing information will also be placed there as well, as opposed to just arriving by paper. Am I correct, Anna, on that issue, or no?
Sorry, Edgar, what was the question?
Is most of the communication will be arriving, like any requests for like clarification of forms, the medical exam, but also the hearing notices and the eligibility interview notices will be arriving through the new portal, correct?
Yes.
Yeah.
The client will receive an email saying go to the portal. There is a communication. Yeah, everything supposed to be by this portal and by email. There is a question, Rui is asking, are more clients to apply by themselves or by a lawyer? Since the pandemic, because the IRCC, the Immigration and Refugee Citizenship offices were closed, especially for the inland claim. The government create like an email that is no longer valid because now people need to do it through this portal. Then the people were sending an email to immigration and said, I'm here, this is my address, this is my passport, and they activated like the claim through that email, then they got a reply from immigration asking them to open an e-post. Through the e-post, the refugee claimant was able to send all the forms and the basis of claim. What we saw with that is many people were coming to FCJ saying, oh, I got a communication from immigration saying that they are going to declare abandon my case, or that they are going to close my claim because I didn't follow up with them. Somebody helped me to send the email. Somebody helped me to create the post, but I didn't know how to navigate that. Then what we are worried, many organizations, we are worried that people is going to see this, or anyone that is going to see, oh, you can apply for refugee protection in Canada, is going to assist the refugee claimant to apply, but if they don't follow up, these bring consequences. Then we need to let the clients know that they are able to get legal aid, and through legal aid they can have a lawyer, or they can go and ask for support to organizations like us or other organizations that support refugee claimants. But we are worried that they are going to do it by themselves, and this is a complicated process.
Yeah. So again, like the IRC will be communicating mostly through the portal. And one of the biggest barriers that we have, both with the e-post before and with other IRCC communications, when, say, for example, that people already become protected persons or convention refugees at RPR, is always make sure that the clients check their spam mail for any communication from the IRCC. Because sometimes Gmail will categorize IRCC communications as spam, and it can be very important notices about providing an update to a form, or for the family reunification process, updating forms for family abroad. And clients will, because they normally just check their inboxes and don't check their spam, will miss communication dates, and months can go by and deadlines can be missed, and it will cause significant issues and delays in their application. And so that's also super important to clarify. The other thing is, as Diana was saying, we're very concerned about, while personally I'm glad that the Epost Connect system is no longer in play, because it's, as you're going to see in the future, it's in the next couple of slides, it's extremely confusing in accessing information. The CRPP portal also brings its own, I guess, troubling issues, mostly because it's how easy it is to start a refugee claim, and most clients don't understand the implications of starting a refugee claim. And I'm going to give you an example from our office where someone was worried about their tourist visa expiring, or their visitor's visa expiring, and they saw that as an immediate deadline to start a refugee claim process in order to restore their status. So the concern right now would be if this person, with the ease of the CRPP portal and not knowing the full implications of what that means, would effectively address the issue of their visitor visa expiring, but at the same time would start the inexorable process of like a refugee claim. So our concern with this is always making sure that clients are aware that even though it's more accessible and easier to start a refugee claim, it also makes it incredibly more accessible or easier to get entrapped into a process that you may not be fully understanding. So for example, if someone is without status for a while and they're like, oh, I can just make a refugee claim, what this portal effectively does is providing your current contact information to Immigration Canada, making yourself incredibly visible, especially if you've been living in Canada without status for a significant amount of time. And the other thing is, if you had a previous status like a visitor, student, or worker, that status is no longer valid because it's overridden as a refugee claimant status. So unfortunately, some clients don't understand that a refugee claim process bars them from entering, going back home and seeing their family members for a significant amount of time. And that can also cause significant stress and hardship to clients here in Canada. And it's also understanding that if any communication isn't met or answered in timely fashion, refugee claims can be considered withdrawn or abandoned, and clients will receive a deportation order. And reopening these cases is very delicate because it requires a lot of information and proof that the client did all they could to provide the necessary information. But clients have busy lives. There are language barriers. They're trying to survive in Canada. And sometimes weeks or months go by missing a deadline. And that just complicates things even further because, for example, if someone needs to make an open work permit application and they didn't realize that their status is now considered non-status because they missed the deadline, it can cause significant hardship and complication for clients down the line. The same thing with missing any hearing dates, deadlines for providing information or evidence. It's incredibly easy to fall through the gaps, especially if you're helping clients who don't speak English as a first language or don't have access to English lessons. So it's also understanding to making sure that clients, normally what we instruct when we're interacting with clients on orientations, if clients have a copy of any communication from IRCC, to authorize us to let us view this communication so we can sort of orientate them on the next steps associated with that, instead of speculating what it could be. More importantly as well is, especially when it comes to appeals, even though it's in the information packages provided to refugee claimants and the ones we provide here, is always emphasizing that when it comes to a negative decision, there is a timeline to make an appeal. So it's always 15 days from when it's received, and it's always making sure clients get in touch with either your organization or their caseworker or us to make sure that notices of appeals are sent on time, and then clients get access to the necessary legal services to perfect the submission or the appellant's record, which is the appeal itself, in timely fashion. But it's always understanding that clients always have to have a deadline in mind, and at the same time clarifying that even though there's very tight deadlines for clients, immigration will take its own time. The current pandemic and staffing issues and hires at the IRCC make work permits take a long time, eligibility interviews take a long time, acknowledgement letters take a long time, and clients are left in a limbo because IRCC is not saying when they can be scheduled for an eligibility interview to allow them to have their work permit. And at the same time, their lawyers can't provide any updates. And in the meantime, clients get increasingly frustrated. So it's always informing them that it's a very unfair system where clients bear the burden of being timely, but IRCC will take its own time.
Edgar, there is a question said if legal aid will cover to apply through this portal. Well, if you get a certificate with legal aid for a lawyer to do the inland refugee claim, then the lawyers should assist the refugee claimant to claim protection through this portal, because this is the new way to claim protection in Canada. Before, again, was through the Epost, and lawyers were assisting the refugee claimants to do it through the Epost. Then now this is the portal. There is no other way to claim protection now in Canada. It's through this way. Then lawyers should, that are covered through legal aid, should do it through this portal.
Also, this is something further clarification. Depending on how relations with the lawyer work out with this first part of filing in the claim and then letter representation with during the hearing, I would suggest that to make sure that the clients ask for access to their own CRPP portal. Because if there's a relationship breakdown with lawyers, it is essential that that clients have access to their own refugee process. And sometimes there have been issues where a relationship is between lawyer and clients break down, and clients are left out without access to their portal. So I would suggest that make sure that clients have access to that at all times. And basically, even it's very streamlined now. As you can see, it's just an email, basically a submission form with your first name, last name, email, country of origin, and it's incredibly simple to start, which is compared to the Epost before is a lot more streamlined. But again, it makes it increasingly easier to start a process that you may not be aware of the consequences of. And especially right now, during the entire pandemic, the new system was the Epost Canada system. So it was originally before you started with an email invitation. And through that email invitation, you would get an email asking you to join the Epost Connect portal. And the issue here is, unlike direct communications from IRCC through letters, you would have to access your Epost Canada profile and account to access a thread. And the issue before is, I don't know if anyone here has logged into Epost before as a private citizen, where you could get notices about your parcels and your shipments and everything. But the issue is, it's very confusing. And you would log into your Epost account and you would have no notifications. So the most important thing in the Epost, especially at this late in the stage where it's already been replaced, clients by now already have an Epost thread, but can't access this. They probably said like, oh, I received a notification, but I can't see it. So it's always important to understand how to navigate that system. The most important part of the Epost Connect system is accessing the thread, or a communication thread, like a chat thread. So what we normally suggest through this is not entering Epost Canada through the normal login, but instead always use the notification email in the client's email to access their account. Because if you just log into the Epost Canada system, it shows as if nothing arrived, there's no updates or anything. But the most important thing is always viewing this thread right here. And it'll basically be a back and forth between you and clients and the IRCC, asking you, for example, for your medical exams, for your updated forms, for copies of your passports, and any additional information. And it keeps a very tight document list of what you need. But understand, like, the issue is always making sure whenever you are verifying that a communication is sent through Epost, always make sure it's through the thread itself, because it will register every point of entry there. And it's basically standard affair, at least if you handled like threads before. It's basically a chat where you can add attachments and everything is recorded. I see a couple questions. Yes, the Epost is being replaced. Yeah. But at the same time, you might be helping clients who made their refugee claims before October 6th and who are still waiting for their eligibility interview, their hearing date, or maybe are missing some submission dates. So for example, if you ever see a client who is uncertain at what stage that they are, always make sure to ask when they made the refugee claim, when they got their letter of acknowledgement, and that way you at least know which system the application is it's linked to as well. So the other issue is how to prepare your clients who come into contact for the first time for a refugee claim process. We've even had multiple sessions with other stakeholder groups. It's a lot of overwhelming information to clients on how to start a refugee claim. It's also dealing with what happened before in the countries of origin, establishing yourself here, dealing with the uncertainty of how the process is, and how to spend your time, because you're sort of left in a limbo while you wait. So there are a couple of resources that we really recommend, and one that is very good for clients understanding what to expect when the hearing is ready is the Ready Tour, which we would highly encourage you to connect clients with. And if you have time for staff or placement students, it's also a very wonderful learning opportunity for them as well. Understanding like how to use your time while you wait for your, say, work permit or your eligibility interview. Because as soon as the process starts, you would get your letter of acknowledgement, which allows you to have the interim federal health plan for medical coverage, would allow your children to go to school in Ontario, and would allow you to access social support such as Ontario Works while you're not authorized to wait for your work permit. While you're not authorized to work while waiting for your work permit. So it's a lot of time where clients are facing a lot of challenges of issues with housing, or maybe they've been fortunate enough to have a stable housing, shelter, and education, but it's still a lot of time of dealing with uncertainty. So we would also suggest like this time can be spent working on the evidence package with your lawyer, your representative, or for example, as we'll see in the future, is working on your establishment in case your refugee claim doesn't work. Working on establishing roots in Canada in the meantime. There's a lot of uncertainty and time in this during this period, and clients can, our experience is that if they can have the opportunity to be more proactive, it's better for their mental health. It strengthens their case. It strengthens their ability to establish themselves here. And if they have access to language lessons as well, it allows them to be more fully engaged with their immigration process. I see a couple questions. Yes, we'll be offering a copy of this presentation, and I know we already uploaded it in our website. The post, Diana, correct me if the post began roughly, I think last year, I want to say maybe August?
Yes.
Yeah.
It was at the end of summer that it started, because everything was closed and it was really hard for refugee claimants to claim protection.
The Epost is the previous system to submit an inland refugee claim, and where the client or the representative communicate with the IRB with all the submit all the necessary form and information to make sure their claim goes through.
But also the Epost now, IRCC is moving to electronic applications, online applications. Then, for example, right now, a protected person, when they get the approval that they are now permanent residents of Canada, they will get a letter, and the letter will say, to get your PR card, now please open an Epost, send us to passport to the pictures, and you will receive it through the Epost, and the landed person, as a protected person, will receive the PR card into the address. Now you can do an application for a permanent resident application, for a sponsorship through a portal too. It's kind of look like the GCK account, the online to apply for a work permit, but that sometimes they will request you to open an Epost. It's a better and safe way for immigration to connect with the clients.
Okay, and I think the other question to the general chat is, how long is it taking for a client to get an eligibility interview? I don't know how to say this because I feel like it's uncertainty and a long time, and it varies.
We have clients that they claim refugee protection in 2019 October. Those clients at that time, they were waiting 3, 4, 5 months for the eligibility interview. Then some of them, the eligibility interview was supposed to happen by March or April 2020. Remember that IRCC closed the offices at that time. Everybody went into lockdown. Then we have clients waiting for almost 24 months, 18 months, waiting for the eligibility interview. However, we have been seeing that recently refugee claimants, the new claims had been called for the eligibility interview, and those that had been waiting 10 months, 18 months, they are still waiting because IRCC haven't resumed like full operations. For example, the 5343 Dundas Street, that is the most common office where refugee claimants, inland refugee claimants were claiming protection and going back for the eligibility interview, is still closed. Now some of them had been called to go to Hamilton. That's the office now that is now open in person. We don't know when the one in Toronto will be reopened. Probably now that we are moving, the more restrictions are more easy, then probably we hope that they will open and start full operating the one in Toronto, because unfortunately refugee claimants had been waiting so long to get the eligibility interview, and without the eligibility interview they will not get the refugee ID. Without the refugee ID they will not be able to get the work permit. Then this had been like causing a lot of stress to refugees, because we, the ones that work with refugee claimants, we know that they really want to work. It's part of that they feel like that they are here just also looking for protection, but also that they feel that they can do something for themselves. Unfortunately, these refugee claimants haven't been able to work because they don't have an authorization to do it.
Yeah. Okay, so the other key document for the refugee claim is the basis of claim, or also known as a BOC. We have access, we've been able to compile it thanks to the amazing work of our volunteers in the past, working translations for each document. We would encourage you, depending if you have clients in Spanish, Portuguese, Amharic, Slovakian, or Czech, to check out our website for these translations. They're fully accessible and easy to download. But more importantly, when it comes to legal aid, it also saves time for the lawyer to perfect a refugee claim and work on the evidence side of it, as opposed to just transcribing information from a BOC and working with the client on that. So normally when we work with clients and refer them to lawyers, it's making sure that they have a head start in filling out the information asked by these forms. That way, when they start working with the lawyer can actually review the case and determine what evidence needs to be obtained, what other clarifications and narrative needs to be set out. And it helps the clients be a bit more proactive and maximize the use of the hours allowed to by legal aid. And always clarify that these translations are not official documents, so it's just mostly to facilitate the communication between the legal counsel and themselves. All right, I think on time I'm gonna allow questions for a couple minutes, for maybe 5 to 10 minutes, and then we're gonna take a brief break, and then we'll get started on the humanitarian and compassionate ground application. So I think we'll be taking some questions right now. Okay, from Nahom, if the refugee claimant received an acknowledgement of claim, she is eligible for OW. Yes, and they will mostly always ask for their UCI number, which is on the top left part of that acknowledgement claim, if I recall correctly. And that acknowledgement of claim is essential to always have for their both for OW and accessing legal medical services as well.
Edgar, also, some people, we see clients that they ask FCJ to do the application for Ontario Works. We ask them, do you have the acknowledgement letter? And sometimes they don't have it. Sometimes the lawyer or the immigration consultant only send them like a screenshot from the Epost portal with the names and the UC number beside that. We have been advocating with social services, asking them also to accept this screenshot as proof that they are doing the refugee claim. because I don't know why. Sometimes we ask them, as your lawyer, you should have the acknowledgement letter, but they said no, they said they haven't received it. This is not a perfect system. Then you get a refugee claimant and said, I only have a screenshot from the Epost with my names, my children's UC number. Please talk to the social assistant, to the social worker at the Ontario Works, and advocate for them and say, this is proof that they are claiming protection. They had the UC number, okay? Yeah. Also, there is a deadline for clients and the representative to submit the basis of claim. Yes, however, it depends from where you are doing it. Like if you are doing it in land, because the portal now you need to send the forms and the basis of claim right away. If you are coming to a port of entry, you are supposed to have 15 days to fill out the basis of claim. Like I came today through Niagara Falls. I will have 15 days. That's the regulation. But because of the pandemic, they are giving the 30 days to refugee claimants, and sometimes we see 45 days. If the people enter through Quebec, like they landed to the airport in Quebec, at one time they were given 45 days. Then it varies, but most of the time, they do it port of entry, at the airport or at any official border, is 30 to 45 days because of the pandemic. But usually it's 15 days that they have. From the day they cross the border, they have 15 days to submit it. Then I always tell them, most of the time in the basis of claim, they put on the acknowledgement letter, they will put in a real yellow saying when they need to send it back. But yes, it's so confused because it varies, 30 days, 45 days. The regulation says 15 days. But because of the pandemic, they have been changing it.
Okay. Rosanna has, how long does this process take until the applicant obtains a PR? So if everything works out perfectly fine, it would be making the claim, acknowledgement of claim, eligibility interview, a hearing date, and then applying if receiving a positive decision, and then applying for PR. At least if I recall correctly, for an entire refugee claim process to go through a hearing, it's almost been taking 2 or 3 years. Afterwards, applying for a permanent resident application takes almost 22 months at least. So it's a significant amount of time. And it's also informing clients that it's a very significant amount of time while they work on this application process. I hope that answers the question. Nura is asking, how much time do legal aid lawyers spend with refugee clients? Do they get a lawyer assigned who represents them, or is it on-duty counsel system? Okay, I think if I recall, for a refugee claims legal aid certificate, it's 16 hours, I think. When we were yesterday in a meeting with another lawyer, that's the time they get to work the case. And that's why it's essential for the clients to make sure the lawyer doesn't have to spend hours filling out forms that they already, instead of perfecting and strengthening the case and addressing the needs of the case, if there was an internal flight alternative, or if there's missing evidence, how to obtain that evidence, or connecting clients to other services or mental health reports that may corroborate their story. When it comes to legal aid, there's always an option that they ask during the call if you already have a legal aid lawyer in mind, or do you need one assigned to you? We, at least here in this agency, we have a list of lawyers who we worked with in the past, who we found to be honest and with clients, and we trust them in the work that they do, and at least being honest with the clients about the realities of their cases. Because it's very important to make sure that clients know that once a certificate is tied to a lawyer, it is incredibly hard to change to change lawyers. It's under extreme circumstances where like a lawyer is no longer able to practice anymore, is ill, closes up shop, or just transfers the file. But it's not something a client can just ask, like switching a representative for like a communications provider or something. So, and always be wary. We try to give clients a heads up, like any lawyer that promises that everything will be fine and perfect is a big red flag. And just make sure that they communicate with the lawyers on everything they need. All right, I'm going to keep going down. If a client receives a negative decision and misses the appealing deadline, what happens? Okay, so for the appeal process, there's a decision date, and there's like a leeway. I think it's almost like 7 or 9 days at most, where a client can officially receive the notice of appeal. And then it's after that date that you have 15 days. Depending on how much time has elapsed, I know Diana and I were talking about certain processes where it's a very complicated process to submit a notice of appeal, but it requires a lot of legal expertise that we are normally not able to handle here at the office as well. Correct, Diana?
For the notice of appeal is 15 days, and plus you can get a period of grace of 7 days. But in total, to perfect the appeal is 30 days. Like 15 days to send the notice of appeal, plus
30 days to
another 15 days to perfect the appeal. But because of the pandemic, since October 2020, the Refugee Appeal Division acknowledged that it's really hard to get on hold of a lawyer or to do an appeal by themselves. Then right now is in total, the process is 45 days, but this can change back to any moment back to the regular time that is in total 30 days from the date that the refugee claimant received the decision.
Okay, Neda has, how can they get their documents back when they obtain permanent residence? What documents do they seize from clients? Normally when a client begins a refugee claim, you give up your passport if you have it, or your national ID document to corroborate your identity. It's not so much getting back their passports, because when you're making a refugee claim, you're asking protection from this country. And it's not a simple matter of just obtaining your passport again so you can travel. What we suggest, what the option is, getting a travel document as a refugee, a convention refugee or a protected person, where you can travel again. But you have to be absolutely clear with clients that they cannot return to their country of origin when they're permanent residents, because it effectively invalidates the whole refugee claim process, because you were seeking protection from this country. And
if they need it, because sometimes they have a visa to United States or something there, or they are rejected refugee claimants that become a permanent residence through the Humanitarian and Compassionate, they can request it to CBSA. CBSA is supposed to have all the file at the original documents when they claim protection. Edgar, we need to be aware of the time because the session will close 10:30, and we need to cover the Humanitarian and Compassionate. Then are we going to take the 5 minutes break?
I think not. I think we're gonna close questions for a while and then move on to the H&C, and then see if we have any time left over for questions. Okay.
Just, I see one important question. When you are considered refugee claimant, from the moment that they initiate a claim through the lawyer, or when they have received the acknowledgement letter? When they receive the acknowledgement letter, or the Epost answer saying, yes, here you have your UC number, and we know that you are in Canada claiming protection. But yes, from the acknowledgement letter.
I'm going to move forward with the H&C application, okay? So sometimes you'll be helping clients who have been here a significant amount of time, or who have exhausted the refugee claim process. And one of the options available to them to regularize their status and obtain permanent residence is a humanitarian and compassionate grounds application. We always make sure to clarify a couple things when it comes to H&Cs, and it's the difference between the refugee claim process and the humanitarian and compassionate ground application. what I always start with is the H&C is an application, if approved, allows you to apply directly for a permanent residence from within Canada. And what it doesn't do is it doesn't stop a deportation or removal order. In some cases, if the case is extraordinarily strong and there's a lawyer involved willing to do so, and there's already a deportation date with a ticket, a lawyer can ask for a stay of removal until a decision is made, but there's no guarantee that it will go through. Unlike a refugee claim, it doesn't call for an open valid work permit application. It doesn't offer any status. You don't have access to medical care or anything. And it also puts you in a sort of a catch-22 where it's asking you for financial independence, but at the same time doesn't grant you authorization to work legally in Canada. So it's always understanding that. And there might be clients who have been here a while and may be considering a refugee claim or an H&C, and it's always informing the clients how both processes differ. And as it says down here, refugee claimants might wait 12 months before applying for an H&C, but there are exceptions, which we will be getting into later. So the key things about the H&C process is you cannot have any ongoing claim with you with the RPD or the RAD or the judicial review. And so for example, if I want to say cover my basis and send a refugee claim and also cover my basis that I want to do an H&C, it won't work. And it's going to cause serious complications for the client in the latter. There's also a 12-month bar after a negative decision. So for example, if I receive a negative decision today on October 22nd, and I am a healthy single person without any children, I would have to wait exactly 1 year before submitting a humanitarian and compassionate grounds application. It can be the day after the next year on October 23rd, 2022. But as a single person who is healthy and does not have children, I cannot apply for an H&C. The exemptions to the bar are the best interest of the child being children in Canada who are directly affected by your ability to stay within Canada. These can be Canadian citizen children who have been born here during the refugee claim process, or other children who have also established themselves here during the refugee claim process, or for another cases with family members who have been here for years and all these children know is life in Canada. So those are the exemptions. So always when you're making sure when you're doing your orientation and asking clients is ask about the family composition or if they have any critical medical care that will not receive any support in the country of origin. So in just making sure, especially when it comes to critical illness, it's just making sure that you work with the client and their medical practitioners for official documentation to demonstrate that they have a medical condition and it's not treatable in the country of origin.
There is a question said if the client, if they don't need a lawyer to do the humanitarian compassion application, you don't need a lawyer to do the humanitarian and compassionate, but you can access to some organizations that will assist you. For example, FCJ Refugee Centre, we do humanitarian and compassion applications. It's completely free. Also, there is a Salvation Army, they do it. However, it will be much better if somebody can support you also to do like the review, because for example, you need to prove that the best interest of the child, then there is some laws and regularizations that you can do the arguments, and it will be much better if they are done by a legal professional or somebody that understands the law. But yes, we have clients that have represented themselves and they get a positive decision. But if they can access to somebody that at least can do the review for the application to see if they are missing something, it will be much better. Okay.
Yeah. And what the H&C evaluates are two factors. We're going to go first into establishment in Canada and then the hardships back home. So as we can see here, its establishment is not also financial, professional, family connection, education, and community. It's everything together. So some clients will be like, I worked hard, I paid my taxes. And what we would normally argue is, unfortunately, what the immigration official will say is that, so does everyone, what else have you been contributing to the community? And so what it's important is as well is volunteering through the community events, either through your faith or your intersecting identities or any general interest. And we understand that there are unique challenges clients face, especially if you're a single parent and you're the sole caregiver. And sometimes what you can say is like, it doesn't have to be an 8-hour volunteer session every week. It can be something just constant, where it can be a couple hours every 2 weeks, where an organization can write a letter of support saying that this client has been a consistent member of community and who has consistently shown care for other community members as well. And when it comes to especially like property and work employments, because they cannot be receiving Ontario Works unless there's a very good reason for a financial exemption. It's also helping the clients understand that they can ask for a letter of employment, and it'll be difficult to navigate with their employers, but it can be done. Employers will be worried about being reported to the CRA, but there's really they're two completely different federal entities, and it normally doesn't cause any issues. And for example, a good letter of employment is not only that they're a good worker, but for example, a very good letter of employment, like this is such a good worker that if they were able to get a work permit later through a positive H&C or their assigned number through a permanent resident, I would be willing to hire them, is a very strong employment letter. And also, for example, demonstrating the paperwork that people are able to are getting income, because some people may be working without status. So it's ensuring that, say, for example, bank deposits reflect monthly payments from a job, or that they pay their rent on time through a landlord letter as well. And for example, like education is also important, because it's not only improving yourself, it also shows integration. The other is letters of support. This is something that we talk about a lot with clients. It's not about volume, it's about specific issues on how clients have their ability to stay in Canada affects them and the people surrounding them. And I know later in the presentation there's a bit of more precise examples, but it's important to have quality over volume. And it's also understanding that clients, depending on their own unique circumstances, will not check everything off. Especially, for example, single parents and they have multiple children and there's no other support system, they will be the primary caregiver and they will have to be on Ontario Works in order to survive. And in that case, it's working around that limitation and asking for a financial exemption, where other organizations, say, organization focuses on the well-being of children, can provide key letters of support saying that, for example, we had a client who was a single parent, sole caregiver, wasn't able to work, but a letter from Children's Aid not only argued that he was a great father figure for their child, but was a caring person and was able to get that financial exemption. So no case will be absolutely perfect all the time, but it's working with what you have and understanding the client's strengths as well. I see a couple of questions, but I don't know if they're okay. Well, we'll answer those later. So the letters of support, there's no, when I talk to clients, people ask if there's a general template. I normally suggest this, if it's personal from the person writing it and it's very specific to each other and how they relate, it's a strong letter. So it should be, it's not only that they will be a great Canadian citizen, it's like, I've known this person for X amount of years. During the, say, for example, our relationship as friends and hanging out, and over the time, we've realized that their life in Colombia, or sorry, in their country of origin, would be very difficult for them and their family. And very kind of like seeing specific, like say, this person, I know volunteers at this agency, at this community center, and they've helped so many people by doing this. And letters of support are not only friends and family, it can also be, say, professionals in like the education system, Also, for example, if clients seek counseling as well, letterheads that prove that they know the client professionally also help tremendously. And I do want to say that volume will not help, especially if they're just the same letter over and over again. And more importantly, instead of just including them in the submission package, it's better to have direct quotes from them in the submission, the arguments of that as well.
Before you move on, there is a couple of questions really important about work permit. Like, can you apply for a work permit if you are doing an H&C? If you are a rejected refugee claimant, what happened with your work permit? Can you renew your work permit if you are doing an appeal? Then the two questions intersect, because if you are a rejected refugee claimant and you are doing an appeal, you are able to renew your work permit, apply to be your work permit to be renewed, but you need to pay now. And unfortunately, because it's right now, you can only renew your work permit through the GCK account, and the GCK account only generates the payment of $255. Then the rejected refugee claimant is doing an appeal to the Refugee Appeal Division or the Federal Court, they had to pay $255. If they were doing it on paper, it's only $155, but because again, now you cannot do it on paper, they had to pay $255. But if you are doing a humanitarian and compassion application, can you apply for a work permit? If you had been without status in Canada, you never apply for a work permit. If you apply for the humanitarian, you cannot get a work permit, okay? Humanitarian and compassionate will not allow you to get a status in Canada, to have a work permit, or to get access to healthcare, as Edgar was explaining when he initiated the second part. But however, if you are a rejected refugee claimant, and you were doing an appeal and you got your work permit renewed, and it was renewed for 2 years, but your appeal was rejected, sometimes people are still using the work permit until CBSA Canadian Border Services called them and said, okay, give me back your work permit, or you can no longer use it. Then people are still using it, even though they are doing a humanitarian and compassion application. But if I've been waiting like for a year and I apply as a rejected refugee claimant through the humanitarian and compassionate, and right now my work permit is going to expire, the one that I got when I doing my appeal, people can ask immigration to renew it again, but the chances to get renewed as a rejected refugee claimant through humanitarian and compassionate is very low. We get clients that get 6 months of work permit doing humanitarian and compassionate, being a rejected refugee claimant. Sometimes they have been denied, but if you are a person that you are not rejected refugee claimant, for example, you overstay your visa, H&C applications will not allow you to get a work permit. Go ahead, Edgar.
Okay. And then the other aspect is hardship. So especially when it comes to former refugee claimants and rejected refugee claimants, it's not related to what happened. It's more related to their intersecting situations and in relation to the power and how they're affected back home. So for example, we had a couple cases from El Salvador where we were able to argue, because some family members were female, that they were face significant issues to their well-being based on the sort of gender violence in El Salvador. And it wasn't related to their previous refugee claim, but it was more specific to their intersecting identities back home. Or additionally, other cases from El Salvador where young boys were recruited by certain criminal activity gangs that was also a specific intersecting identity and would demonstrate hardship back home. Also, back with the issue of health, it's also understanding that there might be health issues where going back to the country of origin is untenable because there's no access to public health care. So especially when you're arguing health, you need the necessary documentation through your family practitioner and analysis back home of what the medical system is. So it's not enough to say like, oh, I'm not in good health. I need specific letters from my doctor attesting that, and reports from the country condition pack as well, or valid news sources where it demonstrates that there is no healthcare support system for the clients. Also, for example, is it showing that there's no access to education, the sort of labor, the employment situation back home. Poverty would be demonstrating that even though the clients have worked extremely hard here, it's no matter how hard they strive back home or back into the country of origin, they're not going to be able to sustain a life for their children, and they'll be directly affected by that. And the final one, which is lack of establishment in country of return. This is particularly important if you ever see clients who are in the youth or who have been here because their family migrated here when they were minors and they lived a significant portion of their life in Canada. So they don't have access to, say, for example, if the client is from Latin America, they don't have access to viable Spanish, or everyone in their family and support system group is here in Canada and there's no one to support them back home. And it's demonstrating that through the family information section as well, and demonstrating that if a person were to be forced to be relocated to their country of origin and there's no one there, you are condemning this person to extreme hardship as well. And one of the most key important aspects of H&C, especially if the situation allows it, is the well-being of children. So it's not only Canadian children, it's Canadian children, foreign national children, children outside of Canada who are supported by the income gained here in Canada. Or for example, if through life circumstances, a client becomes a sort of primary caretaker or support system of a Canadian child here. And that also can be used to strengthen the H&C application and submission significantly. But you can't just say that children are important for you. You also need to have documentation within the form of birth certificates. Letters can be a bit complicated, but it depends on how well the child communicates in English, or it can also be translated, but it's letting the child express their own situation as best as they can and not over editing. Letters from other adults about these children. We had cases where a client's son-in-law demonstrated that the grandparent was the primary caregiver because of financial situations the family here was facing, and that deporting or removing the grandparent would cause significant strain over a Canadian child's life here in Canada. And it's also,
sorry, also I want to mention that there is probably a lot of clients that will say, okay, I'm single, I don't have children either here or back home, then what can I do? I have an example. We have a client that he was a mentor through his mosque, and we were able to get letters of support from the families of the children. And then we demonstrated that many of those children had been impacted because he was the teacher, the religious teacher in that mosque. Also, if you are the mentor through soccer, then try to get letters from the parents of these children. Then we at FCJ, we always say try to be creative and how you can support your humanitarian and compassion application. Then when we do the intake and we start talking with the person, what they are doing, is when you realize, and sometimes they say, I don't have anything, but then we said, okay, but you are doing these things with other children. Can you talk to the parents? Or I'm the one who take care of my neighbors. I pick up them from a school. All these things can be also put as the best interest of children, Canadian children. Okay.
I'm just gonna answer the question quickly from Nora. Like, it doesn't have that they personally experienced yet. For example, if someone, depending on their own, say if their sexual orientation or identity or gender expression, has never been back to their country of origin in the first place, but knows through reports through organizations like a 519 or Amnesty International that there are hardships specific to their intersecting identities, it can still be used. It's better to be more thorough and provide as much information in concrete evidence than to have it lacking. And back to the country conditions documents. So the national documentation packages, which you can search, journal articles that have to be peer reviewed. So one thing that could help a lot as well, especially if your agency has access to certain academic files, or let's say JSTOR, or say through your placement students that they may have access to their own college or university database. That is also a very good source as well. Newspaper articles, preferably in English, but they can also be from other foreign languages, but they have to be translated as well. And clients may find like a bunch of news stories that are related to their case, but it's better to have something concise before committing time and resources to official translations or submissions. So the other thing is how this information can be implemented in this application. So always view this in terms of like not only development for youth and children, but also how it affects your quality of life. So if children are being forced to relocate from the only thing they've known in the last couple of years, how can that affect them in the long term? What does loss of interaction of your only support network that you've known for most of your adult life? Or, for example, what could possibly happen if you had an opportunity to study here in Canada and it was all suddenly just disappeared? And things that can be used for that is, for example, you can ask, not academic, teaching professionals or counselors to, within reason, say, I've known this student for a certain amount of time. What I can attest is that they've shown interest in this area and they choose to be a very promising student. But if they don't have the necessary supports, they will probably not be able to reach these academic goals that they determined. So it's always working with the support system the client has as well. Back to our organization and what we normally provide in orientations is that we also have this wonderful sort of evidence guide for clients to go over and to have a checklist of what they can start providing. Normally when I do my orientations is just go over the information in this presentation and just send a PDF copy of this in their language of origin to make sure they have that when they're working on the application, because the application process is it's a different speed from a refugee claim. Once the refugee claim process starts, there's a very tight deadline to provide everything. H&Cs, it's better to provide as much information as you can, provide a strong submission in order to have the best chance for a positive decision. And we always make sure to tell clients that there's nothing guaranteed. We can provide the best, what we consider the best reasons for an approved agency, and depending on the person reviewing it, on the immigration officer reviewing it on the other side, it can still be refused. And it's always understanding those risks as an agency as well. And we believe that making sure that clients take the time to provide all the necessary evidence is more productive than sending it as quickly as possible. There might be extenuating circumstances where a CBSA is already focused on clients and they're already visible under their radar and time becomes an essential factor. But overall, if clients are still without status for a significant amount of time, have not received any communication from the CBSA, it is best to prepare this as much as possible with as strong as it could possibly be. Additionally, if there are, it doesn't mean that the submission is final. Once an application has been acknowledged, you can provide additional updates further down the line. Say, for example, if a child received a surgery that they can only receive in Canada, or for example, especially during the pandemic where clients were able to complete PSW training programs and provided essential support to Canadian citizens in Canada during the worst part of this pandemic. And that's also can be an important factor for immigration officers or the decision makers to be aware of before they make a final decision. But again, there is no guarantee that it'll be approved. And now we get to my favorite part, which is calling legal aid. Normally what I do is always inform clients that they have an option to apply for legal aid, but I always tend to ask how their income is over the last year. So if you're in Toronto, you can call to the Toronto only number. You can also call toll free if you're outside Toronto. We suggest calling early in the morning between 8 and 9:30 if your work schedule allows it and the client's work schedule allows it. Mostly because, especially now as the borders are being reopened, we do expect a higher rate of calls received to legal aid. And it's also understanding that legal aid agents are human, and sometimes depending on their whims or how exhausted they are, calling late in the day will mean a long waiting list or someone who is increasingly impatient with client applications. So it's best to call early in the morning, and there are reduced waiting times. Clients feel that it's moving forward, and legal aid, I find them more amenable in the morning. It's always making sure that the clients understand that the call to legal aid is always in 2 phases. The first phase is with the first representative that takes the client's general information, assigns them a client number, which is a CLT number, which is something the client and the caseworker need to write down because it'll be it'll be the way they are found within the system. And the client will have to answer questions of when they arrived to Canada, their family composition, questions about their finances, of how much income, how much money they had when they arrived into Canada, how much is left over, what is their housing situation. Depending on your organization, if you have staff that speaks other languages, you can also make the call with the client and make sure that you inform the legal aid agent that you are there with the client either through a conference call or in person, and you are asking permission for the client to consent to let you not only translate but also sort of clarify certain issues if you work in immigration and you know their own unique immigration status. So they'll ask these general questions, they'll be recorded, and they're going to put you on hold. What I normally try to tell clients is that we'll be on hold for a while and that the next agent will ask them the same questions that they just answered. So just a bit of patience, and just to make sure that they are consistent with their answers. The second part of the legal aid call is the legal aid specialist or for the assessment. And this is going to be the person that's going to evaluate the client's financial circumstances and their immigration circumstances up to a certain degree. And they will be the ones either issuing a certificate, letting it sink in for a while and then process it, or flat out refuse. It's very important to brief clients before the call that what they're going to be mostly focusing on are clients' financial situations. And the way I normally break down is even before making the legal aid call, asking clients, okay, I'm going to ask you a very indiscreet question, which is how much has your income been over the last 12 months? And just making sure that you sit down with the client and they have a clear idea how their income was over the last 12 months. Is it, oh, I've been paid every 2 weeks or every month? Okay, how much do you earn? And then we'll multiply that by that so we have a clear image, because the second agent is going to ask a lot of specific yes or no questions. And if clients aren't prepared, there's a lot of miscommunication and a lot of frustration on both sides. And depending on the type of LAO agent that you have, you can receive a very fast negative decision on their legal aid application. So it's always better to just have the client have that information easily accessible, yes or no, specific quantities, so it moves smoothly.
Also, just to clarify, legal aid application, you can do it either for a refugee claimant or for a humanitarian and compassion application. Okay.
Yeah, and when it comes to refugee claimants, they're not going. Clients who may, based on their own trauma, may want to unload or disclose everything about the refugee claim. What we normally suggest is that the legal aid person is just going to ask a general situation. Was it an issue of domestic violence or political persecution or specific threats to your person based on a specific aspect of your life? They're not going to ask about anything else. For humanitarian and compassionate grounds application, they will ask a very existential question, which is, why did you deserve to be in Canada? Or why should you remain in Canada? Clients will have to answer this by themselves, but it's a very difficult question. And even us, with our entire privileges of having permanent residence and citizenship in Canada, I don't feel I can answer that honestly within 15 seconds. So normally what I try to do after doing the intake is like, you've been here for a certain amount of time, you've established to work here, you have family members here as well who are affected by it, and there is hardship back home. And that normally that sort of elevator pitch of for the reasons of staying here in Canada is a lot more clear for the legal aid agent, and it helps, it takes a very significant strain off the client, and it helps clarify that. If everything goes well, clients will be issued a certificate number, which is a CE number, which is what clients will be offering or giving their lawyers once they agree to work with them. It is incredibly important to have them write this down, and if they authorize it, to at least keep it in your database in case they lose it or it's misplaced. Other aspects of it is that depending on the client's ability to access technology or navigate email, they will ask you to log into their client portal where any communications from legal aid will arrive there. The most important part of this communication that will be arriving through there is the letter of consent, which will disclose what authorization the client gives to legal aid to verify their information, and that they are obligated to provide any updates in their addresses or in financial situation. The other question is, what happens if you have a negative decision for legal aid? And I think I'm going to go just over this section first before that. And for the legal aid application questions, it doesn't have to go on specifics. It just mostly what happened briefly and what are your financial resources to pay or not a lawyer. They'll ask clients if they even have GoFundMe accounts, which is, I have not heard of, in the couple of years that I have been here, I have not heard of any client having a GoFundMe account, but they will still ask that question. So before that, what happens if you have a negative decision from Legal Aid Ontario? You can appeal the decision within 15 days and they'll receive a communication to do so. But the key understanding is making sure that you ask, or the client asks the specialist why it was rejected. If it's for financial reasons, it's making sure that you go over with the client to see how their income was over the last 12 months, how many family members are involved, and doing a breakdown of their income and demonstrating that through either bank statements or any other, or say a letter of employment if they've been here a while. If it's not for financial reasons, and it's for the validity of the legal aid aspect, which is rare on refugee claims because legal aid specialists are not legal specialists, and they normally don't have the qualifications to assess if a case is strong enough or not. But there might be cases where you're applying for legal aid for an appeal, or depending on what the client answered during an H&C application, that they might feel that there's not much of a strength in that.
Edgar, we need to be aware. We were told that at 10:30, the system will close down. It's 10:27.
Okay, I think.
But I think this is the last one.
The key aspect is making sure, especially with financials, writing the entire summary of the last 12 months and getting that appeal in on time. And as for the other one, making sure that clarifying that the specialist doesn't have necessarily the legal knowledge to do an assessment in a very close amount of time.
Edgar, one question was, why, if legal aid have interpreters, why you want to support the person? You need to do an assessment. For example, these days we have a case from the person, the client was speaking Russia, legal aid given an interpreter, but we saw that also the client was really confused. The interpreter was not doing a great job, but we support them when we see also that they are really vulnerable, that they have probably a lot of trauma, that they don't trust, especially refugee claimants. When you arrive, you don't trust authorities, you don't trust people, even that you are talking on the phone. Then that's why sometimes even there is interpreters on legal aid side, we do the the analysis and we see this person needs our support. Yes, we don't call everyone for legal aid, but we assess the case. Another question was the DCO countries. The DCO countries is still, but is not like affecting like before. Now, if you are from a designated country of origin, you can appeal. Before you couldn't do the appeal to the Refugee Appeal Division, you had to go to the federal court, but now you can do the appeal. The timelines now are the same for DCOs or from any other country. The designated country of origin is the Minister of Immigration who designate them. There haven't been any new countries designated there, then really is there, but it's not affecting the timelines or who can appeal or who cannot appeal a rejected refugee claim. If somebody can contact Edgar directly, yes, here is his information, or anyone can contact FCJ Refugee Centre. Edgar, I don't know if you have seen that we are missing another question.
Does legal aid cover refugee claim appeals? The issue with this is that because refugee claim appeals are on such a tight deadline, legal aid may ask to review the file, and it'll ask for the client's notice of decision and the reasons for the decision, and they will take a significant amount of time to either see if they approve it or not. So
also they can approve it because they can pass the financial, but then the lawyer will only get 3 hours to do a merit of assessment. Then the lawyer can write to legal aid and say, yes, I believe we can win this case, but legal aid can say, sorry, no. Then the second part, to perfect the appeal, may not be approved by legal aid. Most of them, they will say only approve the first part, that is the merit of assessment, 3-4 hours to a lawyer. But to perfect the appeal, most of them are denied on the basis of merit. I don't know if there is another question.
1 second. Country of origin. I don't think so.
Yeah.
I think the session's been closed by Felix,
Okay.
so.
Oh, okay.
Okay. I guess thank you everyone for joining, and I hope this was informative. And thank you, Diana, for all the support.
Thank you, guys.
Diana, I think you're mute. Sorry, Daryl, is it okay to head out, or?
Yep. I'm just going to end the meeting and we're good. Thanks.
No problem. Thank you so much.
Yep, no problem.
Have a great day.